I remember a situation where I was representing one of the spouses in a same sex couple situation. There were two females, and one of the women was the biological parent to the children of the marriage. One of the children was adopted by the other spouse, by my client, and the other child, they were in the process of doing the adoption, but it wasn't completed. Once they started going through the divorce, this became a major issue because obviously there's love, there's connection, there's attachment to the children that you're raising. There was a definite concern with respect to the access that my client would have to both the children. So she actually wound up only having rights to see one child because she adopted that child. And the other child, this is going to sound very strange, but she had the choice. She had an option to choose if she wanted to fight to have those rights for access to the child. And if the other parent would agree, then of course they can have the access schedule. But if the other parent didn't agree, or maybe if my client didn't want to have access to the child, they didn't even have to pursue it because they didn't legally adopt that child. It was a very interesting situation. And depending upon your situation, you might wind up in a similar scenario. We didn't wind up going to litigation and trials and motion practice in that particular case, and it was settled out of court.